sign. You ain't holding nobody hostage. The trustee can say, hey, man, I don't want to do this. He'll do a letter of resignation, and you appoint another trustee. No big deal. It says in paragraph 16 that the trustee may at any time be terminated by the persons holding the power of direction over the trust. Let me understand this, guys. Understand this clearly. You don't have to have a reason to fire your trustee. You just call them up and say, man, you terminated. I'm appointing somebody else. Just wanted to let you know. I'm sending you something. You can sign it or not sign it, but we're replacing you. Okay, we're replacing you as trustee. In paragraph 17, that deals with how long the trust actually can be in effect. So it says that in the event any property shall be remaining in this trust 20 years from this date, then basically the trustee could actually sell the property, dispose of the property. Guys, they put stuff in here because this deals with the laws of perpetuity. This basically what it does is it tries to make it so that individuals in a generation have the opportunity to be able to own something. Okay, because you want to have somebody that wants to put something somewhere and hide it from 2 generations and skip over everybody. And I'm trying to have something go to somebody. In other words, this person's trying to control an asset from the grave. Totally. Okay, that's why they put stuff like in there, like that in there to have an expiration date. Okay. All right. It says in paragraph 18 how much money the trustee is getting for taking and holding property, holding title to the trust. And guys, that's your document. That's your agreement. That's the contract. That's your trust agreement. Okay. Now there's some more documents, but that is the meat and potatoes of your trust agreement. Okay. You're going to sign, all the beneficiaries are going to sign that document. You can witness or not witness. Witnesses aren't actually required, but if you list it and you put witnesses, go ahead and just get you some witnesses, because then you have somebody saying, well, I don't see a witness there. But witness is not necessarily required, but I might recommend that if you leave the witness signature in there, then you would go ahead and do that. All right, and then you're going to have the documents notarized. Page 50, that is your legal description of the trust document. That's where you say, see Exhibit A or whatever. So that gives the actual legal description. Being known and designated as lot, whatever it is, on the map of whatever county, what the deed language reads. All right. The next page, this is the important page, page 51. This is your warranty deed. Listen to me closely. This is your general warranty deed. Remember, you are deeding your property from yourself to your trust. Okay? So the deed, you want to make sure the deed. Now, you're going to get the documents that you see in this book. What I'm going to tell you to do is when you get a deed, you want to go to your local county and see what their actual format is for deeds. All right, in your state or in your county. Some counties say, like if you look here in North Carolina, you got to have so many inches from the top of the page for the document to be recorded on the first page, on and so forth. You have some counties that record a long deed. They'll have an 8.5 by 14 whatever sheet for deeds. So you want to go and find, if you live in a state where your deed doesn't look like this, you're not going to take this deed down there. You're going to go get a deed that's compatible with what's being recorded in your state. Okay. All right. So you may have to go request or find a deed. All right. So that you can take and record what's actually being accepted in your state. You may go down to the registered deeds office. You might go on to your county registered deeds website and just look at deeds and see how they look, see how they're formatted, see what they look like. Okay. So you're going to fill out the deed, and remember, you might want to write on page 51, this gets recorded. All right, because this is what actually puts the property in the trust. And you see that the grantor, that's the person that's initiating the trust. That's the settlor or the creator of the trust. That's the grantor. Remember when I said earlier, I said sometimes when you start talking to attorneys or you talk to somebody and you say, land trust, and the eyeballs start spinning around and say, well, I don't know nothing about no land trust. Generally, that's where you say grantor trust, because they understand that the grantor or that individual that owns it or whatever is granting something to someone else. All right. So James Goodman and Mary Goodman are granting their property to the trust, and they've named the trustee and with the trust address, trustee's address, and all that stuff. And that's where all the documentation is going to go. So sometimes, guys, if you're naming, just a little caveat, if you're naming a trust, or you're naming your trustee, and you're naming a mailing address for the trust, you might name a mailbox that actually doesn't go to the trustee. It has the trustee's name, but you name a mailbox where the mail actually comes to you. Okay, so you're getting all the mail. Your trustee never actually sees it. You might not want all the documents to go to your trustee, but again, you're going to make sure you have a private mailbox that nobody can really, determine that is actually you. Or you may have a situation where you have to go to the trustee, and then you just know your trustee. You tell them, hey, any correspondence you get, you just mail it to me. Okay, that may take up and make the process a little bit lengthy, but that's what your trustee does on your behalf. All right. Hopefully that is some clarification in that regard. On the next page, page 53, this is your affidavit or certificate of land trust, denoted as Exhibit B. In this paragraph, or in this document, this is the affidavit and certificate that I talked about. This talks about the trust and just gives a brief summary of what's in the actual agreement and declaration of trust without telling anybody everything that they don't need to know. It says who the trustee is and what their responsibility is. It says that in paragraph 9 in particular, that in no case shall any party dealing with the trustee in relation to the said real estate be obliged to see anything about the trust for the most part, about the trust agreement. So all that is there in that actually recorded document. So this is where the trustee can legally say, hey man, I can't tell you that. I would be in violation of the trust agreement if I tell you who the owner of this trust is. I can't do that. Now, if they go get a court order, then maybe something else. But like I said, that he doesn't have to say or divulge any information. All right. One thing I want to point out, and I didn't point, this is actually in the trust agreement itself as well, and I didn't do it in the trust agreement, but I'm going to do it here. It says that if you go to page 54, in paragraph 12 and 13, it talks about the situs of the domicile of the trust, or the situs of the trust. Guys, the situs of the trust, guys, is that place where you're going to have the laws interpreted, reinterpreted, or governed by that particular state. So you could actually have a trust that you form for North Carolina property, and you have the situs of the trust in another state. So you could say the situs of the trust is Virginia. And the reason that you might say that the situs of the trust is Virginia is because Virginia has some very strong trust laws. Virginia has one of the strongest trust laws in the United States. So Virginia is a great place, Delaware as well. But Virginia probably is number one. There's some others, but Virginia is probably number one. So you might say, if you have some colleagues or some friends in Virginia, you might have them be your trustee, and you name Virginia as the situs of the trust. Now, one thing for you guys that may be listening or in Illinois, Illinois has some peculiar rules. Remember, I told you they understand trust most better than anybody. Okay, because they were originated. That's where they started in the United States, in Illinois. So in Illinois, you're going to have more people more familiar with everything we're going through. This old news. Okay, it may not be that everybody's doing it, but it's old news. More people are familiar with it. And so they have certain laws in Illinois where you may have to disclose a transfer of beneficial interest in whatever on public record. So you just be careful in Illinois. So in Illinois, if you were forming a trust, you might want to have the situs be somewhere else. Okay. All right. Everybody follow me? All right. Let's go to page 55. land trust beneficiaries agreement. All right, so on page 55, guys, this is the beneficiaries agreement for your land trust. This is where everything, all the meat and potatoes relevant to the beneficiaries is. So whether this be your home or a joint venture, if you was doing a deal with somebody, this is where you guys would decide everything. And you're able to edit this document, and maybe you have an attorney or someone help you draft what your actual agreement is. So this is kind of just like having a partnership agreement, but you're not partners. Both of you guys have individual interest in a trust. It does not form a partnership. Okay? You're not actually partners. Both of you just have an interest. Have both of you basically share beneficial interest in the trust asset. All right. So if you look at this thing down in paragraph 1 under the duties 1A, it says that the beneficiaries have the power of direction over the trustee. So basically, you got the power to tell the trustee any and everything. You're managing that trustee. It says that you have the right in part B, 1B, to receive the proceeds and avails from any rentals, sales, or disposition of the personal property. It says that you have the right and duty of management of the property. All right. And that you have the obligation for the expenses and disbursements relative to the property. And then it also names down there in paragraph 2 that you hired management and whoever it is that you hired as the manager. And this is all, we've kind of went through this information, but now you're actually seeing it on the beneficiaries agreement itself. All right. It says that in paragraph 3, that's important. It says co-ownership and division of profits. That's what I basically already talked about. It says the parties expressly disclaim any relationship among each other or as that of, that they disclaim any relationship among each other as that of partners or in a partnership, because you're not in a partnership. All right. Both of you guys just have a beneficial interest in a trust. Now you can look at it, 6 and 1, half a dozen of the other, but this trust owns the property. You just happen to have a beneficiary or beneficial interest in the trust. All right. It talks about the funds and how the parties will maintain a checking account and make contributions as necessary. Books of account, who's going to maintain the books. And in this paragraph, guys, if you were doing a joint venture or whatever, you may say that this party is going to actually maintain the books, and the books will be provided for inspection by the second party who's not maintaining it. Upon their request, then the books will be provided, on and so forth. So this is a document, guys, that's pretty fluid. You can put information in there as you see fit to fit your particular situation. If you turn to page 56, it says income taxes. Each beneficiary, paragraph 7, it says each beneficiary should be liable for any tax consequences that come out of this trust creation. Transfer and sale of beneficial interest. It outlines that each party should have the right to sell their beneficial interest, in the trust. Now, you may have some provisions in here that says that one of the parties has the right of first refusal. So you can make this document say what you want it to say. You can't sell nothing unless I have a right of first refusal, and I get to do this and I get to do that. All right. So, and that's actually in that document. In the document in paragraph 8. All right. Again, you're going to sign, notarize, and that document is complete. The next document, you see, page 57, is your notice to the lender. Now, that's in there, guys. I'm just going to tell you this. Don't send it. They don't need to know nothing. You just keep sending your check. They ain't worried about it. Okay. You just keep sending your check. If they ask you something, you send them whatever you want to send them, but you don't necessarily have to do this. This is in the program. You can put down there, hey, I wouldn't tell you, there's no sense in sending it. It's not required. All right. And you see the language it says that, please, dear sir, please be advised that we have placed our property into trust for estate planning purposes. As I stated earlier, guys, we're saying for estate planning purposes. We're not putting stuff in there for asset protection. If you go to your bank, particularly when we get into talking about personal property trusts, and you're going to do a trust bank account, or you're going to do a trust where you're going to put your car in. If you go to the bank and you tell them, hey, man, I want to open up this little side account, because I went to Tony's workshop this weekend. He told me I need to do this so I can hide my money. So I need to set up this account, right? And I'm doing this for asset protection. Why you set up the account? For asset protection purposes. I told you they ain't worried about you protecting your assets, okay? So you go in there and you tell them, well, I've been working with an estate planning attorney, and he recommended that I open up a trust bank account for estate planning purposes. And what people think when you say that is that you open up an account because you're trying to administer your estate. You're trying to take care of your affairs so that if something happens to you, you have your affairs in order. Okay, it's not like you're doing something devious. You're trying to manage your estate. And people that have money, this is what they do. So it's a common thing. Okay, people that have money, this is how they carry themselves. All right, the next page, page 58, actually, that's just another document, pretty much the same thing. So you would send something to the bank. You may send something. If you were sending something, you would have sent it to the bank. You may have sent something to you're definitely going to send something to your insurance company that notifies them that you put the property in trust. All right. And you're going to tell them how the new how the new declaration should read. So the property is going to be titled. So the named insured for the trust is going to be the name of the trust. Okay. With the trustee as an additional insured to that. And then the beneficiaries would be an additional insured. I'm going to illustrate that to you. We're going to show you that in slides or whatever. But that's pretty much the trust, guys. As far as the pertinent information, here goes what I told you earlier. All right. So two individuals want to actually joint venture together. And rather than just forming a partnership or whatever, you're basically, what you're doing is you're going to put the properties in your land trust, and each beneficiary is going to have a 50% beneficiary each, but they're going to have that beneficiary interest by virtue of a personal property trust that each one of them prepared. So partner A is going to form his personal property trust. Partner B is going to form his personal property trust, and they are separate and apart from one another. Okay. Now, some people going to have a question. Can I finance a property in trust? It depends. It depends. If you're dealing with most lenders on the secondary market, your Wells Fargo, your Bank of Americas and all that, if you go to try to obtain financing while your property is in trust, in most cases, these guys are very, very peculiar and feel timid about trust. So in most cases, they're going to tell you, we can do the finance for you, but we can't finance it in trust. And typically they might tell you, you will do it in your name. You want to put it in trust later, that's on you, but we don't want to deal with it in a trust. So it's better to find other individuals, usually your small local banks, institutions that have, that maintain their portfolio in-house. They will be more inclined to finance the property in trust. I know that a lot of banks, smaller banks, what they will do is they will have you do something that's called a hypothecate letter, and they'll require that from your trustee and yourself to actually keep the loan in your name. I've actually refinanced properties with a certain bank that I use that refinances the property. And guys, it's hard to remember sometimes that you don't own the property anymore. I remember years ago that I wanted to refinance a property, and I went into one of my local banks and told them that I wanted to refinance the property. And usually I wanted to do a line of credit on the property, and usually they give me a loan fairly quickly. Within about 3-4 days, they tell me, hey, your line is good. Well, I remember the loan officer called me up like, Mr. Robinson, just what are you doing? I'm like, what's up? How you gonna have me finance a property that you don't own? And don't own? What you mean I don't own? It says some John so and so and so and so. And I had forgot I had put the property in trust. I wasn't thinking from that perspective. So I was like, oh, okay, the property's in trust, that's the trustee. And what they did was they just made me do the hypothecate letter, and allowed me to get the loan with the property still in the trust. But again, a secondary market lender, like a Wells Fargo, Bank of America, SunTrust, they're going to probably tell you they're not going to finance the property from Jump Street inside the trust. All right. So you may want to go to a portfolio lender, someone, like I said, your smaller local bank, to get your property financed. That pretty much, guys, wraps it up on the land trust itself. So there's land trust, and then there's personal property trust. The personal property trust, we're going to get into that in the morning, and then we'll get into the sub 2. On the personal property trust, tomorrow is going to be sweet, because you're going to learn how to actually do the subject to concept, put properties in trust, utilizing this trust concept, okay, that I'm teaching you today. I'm just going to, I want to just show you one thing so you can marinate on this, chew on it. Hopefully it doesn't go too far over your head, getting ahead of myself just a little bit, just so you can see the benefits. So what actually happens when you do a subject to transaction, and I want you can see me do this, is basically what's going on when you do a subject to. Just so you know, just what we just went through. You're going to create a trust. All right, you're going to create a trust. You're going to have the seller deed the property to your trust. All right, and now you have the beneficial interest in that trust. Now I'm going to explain something to you, and you can marinate on this, because there's gurus out here that teach this stuff a whole bunch of different ways. All right, and I have learned through a lawsuit and over time. So this is the way that if you go to a lot of people that teach this process, they will tell you how to actually do subject to, and they do it a little bit different from me. So I'm going to show you. I'm just going to show you a couple examples of the subject to deal. And some of you may have seen this in some of the other workshops. Here's an example, all right, because some of you that actually think you got to have money for everything that you do, right? Because I'm telling you, hey, Tony's telling me that I need to actually put something on my board. I don't have no money. I don't have any credit, okay? Well, subject to may be something that you're considering. I'm going to tell you, I told you this already, subject to may not necessarily be for you, all right? It's an advanced investor strategy. We're going to really dive into that on tomorrow, but basically, you know, a lot of people think it takes money, all right? So you thinking it's taking greenbacks for you to actually do that subject to. Here's a situation where one of my clients had gotten paid, and the seller paid him $30,000 to buy her house. So you see the house there. He got paid $30,000 when he sat down with her and presented to her, educated her with her, and negotiated with her. And she knew that she did not have enough equity in that house to make that a deal worthwhile for him. So she eventually bit off. You know, he told her originally that he needed $40,000. Well, she called him up and said, would you take 30? And he said, yeah, I'll take 30. So she paid him $30,000 to buy that house that you see on the screen. That's a pretty nice house. And that's where he sent me an email. That's his exact email, copy and paste, saying that, hey, closed on the house pretty much, and lady paid me over $29,000. She actually paid $30,000, but she had some seller cost. And he took the property sub 2 at 170. Seller paid him 30. He gave it to a tenant. He gave it to a tenant that did a rent to own. Okay, tenant did a rent to own, because he put a sign in the yard, right? And now a tenant, option tenant, gave him $9,000. So he has $39,000 in his pocket with nothing out of pocket. Nothing out of pocket. He didn't need any money. He put $39,000 in his pocket and bought a house. You know, that's sweet. That's sweet, guys. That is sweet. Here's just show you real quick another one. Here's one that I did in my area. I purchased this property on a subject to several years ago. Bought it for $219,000. I gave the seller $11,000. I actually paid $11,000 to take control of that house, had them deed the property to my trust, took over that property sub 2 for $208,000 and kept it for about 30 months, I believe. And here at the end, I got an $85,000 check out of that. You can see it's made out to my trusts, to a trustee. So we're going to talk about all of this on tomorrow. When I show you stuff like that, all I like to say is back up the truck. You know, you see the truck out there, we're going to back it up, because that's making money in this business. So again, on tomorrow, we'll get into that. But basically I want to show you two things, and this is what we want to avoid. And I'm going to tell you why. And this is just getting a little bit ahead of myself, but just so you can kind of see a subject to transaction. So in this transaction, all right, what you actually have is a seller, all right, or a homeowner, and they have a deed, all right, and a note with the bank. Okay, they hold the deed, the bank or the mortgage company holds the note, all right. They become motivated at some point in time, and they decide that they want to sell their property, and you come out and convince them you want to buy it. And so you have a trustee appointed, or they appoint a trustee. They make their own individual trust, all right, and they get the original beneficial interest. The beneficial interest is with the seller, okay? And then on the quiet tip, they assign their beneficial interest to you as the investor. Y'all see that right there? You see that illustration? I hate it. Don't do it. I don't like that. Okay? That's what got me in a bunch of stuff. Nothing wrong with it, but that can cause problems. So, because what happened is, guys, when they went to originally deed into the trust, they deeded the property into their trust. And their last name was Smith. Okay? They deeded it into the land trust as Smith Family Trust, right? And simultaneously, they did an assignment of beneficial interest over to you, all right, as the investor. And so now you own the property, okay? The way I like to do it now, and we'll get in more detail with it tomorrow, is that this is how I tell you my suggestion for doing it. Same situation, all right? These guys actually, before they motivate, they're making payments to the bank, all right? Subject to, basically, all you're doing is taking over somebody's payment. So the seller or the homeowner's making payments on their bank note, all right? They become motivated for whatever reason, and what they're going to do at this point in time, you're going to have them deeded directly to you, your company or your trust that you set up. And then you start making payments, okay? All right, you start making payments instead of them. That's subject to in a nutshell. We're going to get into all of how you do it. I'm going to show you some role play type stuff, show you how to language it, how you get people to want to pay you or realize that they need to pay you. So we'll do all that on tomorrow. Let's see. Again, guys, just a little bit refresher stuff. You want to make sure you have a distinctive divide between yourself personally and your business activity. Okay, so that's through the formation of that entity that you created. For most of us, we want some type of LLC, and we can have it elected to be taxed as appropriate for our situation. But basically, that's what we're doing. One other thing, as I get ready to wrap this part up and take a few questions, maybe. I did not talk about the role of insurance. So I want to talk about that because insurance is a part of your asset protection plan. It's important to get insurance. Guys, so you want to make sure that you're covered. You want all the liability insurance that you can get. You want to get the maximum amount of insurance that your insurer will that your insurance company will possibly allow you to get. All right, because insurance, guys, they have a duty to defend you. All right, or pay for your legal defense. All right, in cases where you haven't done anything fraudulent or contrary to your insurance agreement. All right, so you have a tenant trip and fall in your house, then of course your insurance fees or your insurance is going to defend you. Now, that doesn't mean that's the be all end all. If you have $1 million policy and you have a $3 million lawsuit, then guess what? If you lose that lawsuit, then it's a good chance and possibility that you're going to have a problem. Okay, you're going to have to come up with some money. All right, and so you got to make sure that, number one, it tells you up top, it tells you that you want to make sure that you don't undercapitalize your company. And if you have, then of course, the insurance will be something that's going to help you subsidize any claims. Okay. Recommended as well, you get maximum liability coverage as they will possibly allow you. And then you also want to get an umbrella policy on top of that. So if you can get a $2 million, $3 million umbrella policy, you get all the general liability coverage that you can get, as well as an umbrella policy, so that that umbrella policy will kick in for anything that your regular policy did not cover. Okay, so and insurance, for the most cases, guys, is not as costly as sometimes we think. One thing I want to go back to as well, just kind of going through, I want to talk fairly quickly on another part or another aspect of your asset protection plan, and that deals with your LLC as well, or your company, in making sure that that company, LLC, or whatever you're using, provides you with charging order protection. All right. So that's one of the things that we want when we start talking about limit liability companies and whatever. Charging order protection. Charging order protection, guys, every state does not allow charging order protection. California is one state they're crazy out there in California. Feel sorry for y'all, if anybody on here. But California is one of those states where if you're 1%, if they find that you're 1% negligible, you're 100% liable. Okay, that's California. So you don't want to, you want to make sure, guys, that you want to check with your applicable states and make sure what they actually, what's in their statutes relevant to charge and order protection. Charge and order protection is simply what, if someone were to sue you or whatever and go to court and win a judgment against you, a charge and order is what gives you, charge and order protection gives you a shield from that order that they're trying to place against you. So if you have, let's say for instance, someone wins $1 million judgment against your company, okay? If you have charge and order protection, a court will not order or cannot order you to dissolve your company or whatever in order to pay that your liability in that claim. So basically, because that's one of the important parts or one of the important components of having a multi-member LLC. Because if you have a single member LLC, the theory behind that is that if you're sitting in court talking about, well, that would not be appropriate because you you're causing me an undue burden. If you're the only person in the company and you're saying, well, Your Honor, it wasn't me, it was my company. Well, who's in your company? It's just me. Okay. So now you may be exposed. Judge said, I'm not going to allow that. This was you. This was your action. But if you have multiple members, the theory behind it is that they don't want to harm another member of the company being harmed because of the liability or actions of another party to the company. Okay, bringing harm to that individual. So if you have a charging order on you, if you have charging order protection, most attorneys that would actually sue relative to a charge or try to go after you with the charging order won't do it because of this. Charging order like puts a blanket on everything. Okay, covering everything. Now, the only way that you actually are going to have to pay something relevant to the charging order is if you make a disbursement. So if you're dispersing funds, then that stuff has to go to the plaintiff that won. So you can say, we're going to retain it. I'm not making any distributions. We're not doing anything. And no one can actually make you. In some cases, that plaintiff's attorney or that plaintiff could be responsible for paying taxes and paying the expenses of your company during the time period that this charging order is in place. So that's why most of them will not do that. So we want to have charging order protection. I'll talk about that just a little while tomorrow in a little bit more depth, because we're going to need to talk about that as we talk into trust, another part of trust. But let's see. If there's one more thing, then I'll just go to answer some questions before we wrap it up for day one. Okay. I believe that I have covered everything. I want to say one thing, guys. I'm just want to make this before I get into that. All right, many of you, because I get a lot of calls, a lot of emails, text messages. Mr. Robinson, what you think is going on? You guys heard me talk about. I did an interview with Max about what I thought about the state that we're in relative to COVID-19. We talked about some of the laws that are in place now as well, that are coming out. You saw Illinois basically outlaw or ban wholesaling for the most part, as most of us know it. And I told you guys that, this is something that we have to get on top of, because if you don't pay attention to the legislative aspect of it, you'll find yourself having been legislated out of business. But if you look at my slide real quick, I just want you to see this one. What I want to tell you on the slide is that there's really no need. Can you put that one up there? Okay. There's no need to panic, guys. I've been around and there's always legislation, but we need to make sure that we stay abreast. Since I've been in this business, there's a whole bunch of things that have come in effect just since I've been around. I've been around a while. Passive laws rules, rent control, lead-based paint requirements, local ordinances, compliance inspections, financing and banking rulings, seller disclosure, EPA rulings, storage tanks, asbestos, radon, rental property tax rulings, lease option rulings, Dodd-Frank, foreclosure rescue, mortgage interest deductions, capital gains taxes, Fair Housing Act, Illinois wholesaling. Guys, the whole thing is that you just have to make sure you maintain an ear to your industry, understanding and knowing what's going on in your area and getting that brought to people's attention, so that when some of our legislators come up with something that they're trying to take something away from us, we can try our best to get a seat at the table and have a say-so in what's going on. And that comes from owning property. If you don't own nothing, I'll say this all the time. If you don't own nothing, you don't have nothing to say, point blank. A lot of us, we get mad about a whole bunch of things and we don't own jack, okay? We get mad and we start talking about gentrification and all that. The clue to gentrification is own something so you can get a seat at the table. That's one of the things you do. Okay, we go out and get disgusted and watch other folks and people do this and do that and get mad, but we don't own nothing. You don't have nothing to say. Don't nobody want to hear you. Okay, so own something. All right, let's go look at the questions. All right, says, where should you store the trust documents? You store the trust documents anywhere you want to. You're in a secure create a filing system, just like you would for your property management, rental agreements, or whatever. You want a secure file cabinet. Maybe if you're paranoid, maybe you have at the bank you use a what is it? Safe deposit box or whatever. Use a safe deposit box. But you're just going to store them someplace where you can keep them maintained. All right. Want to make sure I understand correctly. If wholesaling, it's best to use the LLC and ask the CPA to tax me as S corporation. Well, you asking your CPA, you really asking the IRS to have you electing to be taxed as an S corporation. And so basically what it's going to require is for you to make an election to change your current tax election utilizing Form 2553 to go to the, to send that application into the IRS to elect S corporation status. They actually review those documents and make a decision as to whether or not they're going to actually allow it based on whatever your submittal is. Why not convert the LLC to S Corp? Because you can convert the LLC to S Corp, but I'm just going to say this: S Corp has certain formality requirements. If you convert the LLC to an actual S Corp, then you're held to that standard. I'm just saying that for simplicity's sake, most of us are not going to do half of what's required to make sure that we keep that company viable, because we're not going to do all the formalities that are actually required. So I would tell you, simplest form and fashion, have that LLC elect S corporation status. All right. Can your property be subject to a lawsuit if your trustee finds himself or herself in a legal situation? Well, if your trustee did something, yes, your trustee, it may be a common circumstance. We have seen this where someone tried to come and try to attach something to a property based on the trustee. But once they found out that the trustee has no liability to the property, trustee doesn't own the property. He just has a fiduciary responsibility to manage the property on behalf of the beneficiaries. So no, they can't do anything to your property through the trustee. If you place your personal residence in the land trust, can you claim depreciation? And I'm just going to tell you point blank, you got to know what you're doing. You can't claim depreciation. Your personal residence is not a rental property. You only get depreciation on a rental property. Now, if you make your personal residence a rental property, then you can start claiming depreciation. There's no depreciation for personal ownership. If the bank calls the loan due, can I still make the payments and keep the borrower's credit in good standing? Well, you can keep making the credit. You can still keep making the payment up to and through the point that they decide that they want to exercise foreclosure. Typically, what happens, guys, is they're going to send a notice out saying that they found out that the loan has been transferred or whatever, and you got 30 days or whatever to actually let us know what's happened here, because right now it looks like there's a change of title or whatever they say. And then you're going to respond or not respond. And after that, their only remedy, if they want to do something, is to actually foreclose against the property. So what you would actually have to do is you would have to either work something out with the bank to actually pay the loan off. That's one of the detriments of subject to, possibility that you may have to pay the loan off, or maybe you go back to the seller and you rearrange things to where it satisfies the bank. Okay, but due on sale, guys, I have been doing subject to a long time. I only know of maybe a couple of incidences where an individual actually ended up having a property taken during due on sale. Now, I personally, to be honest, I've had sellers get mad and threaten to call their bank. That's something that could actually happen. They decide, hey, look, this property been in my loan, this loan been in my name. When the heck you gonna pay it off? I can't buy no car. I can't buy a new house. I want it gone. You already had it 3 years, 4 years, or whatever. And then they get mad and they could call the bank and tell them, hey, I sold this knucklehead my property and I don't know what's going on. Now they just told the bank. Now, matter of fact, they could have hurt themselves because the foreclosure action is going to be against them. So, and now you all in a big mess. But I've yet to see that actually happen. And what I tell people is good bedside manners. It always goes back to good bedside manners. Oftentimes, guys, we get into situations where, it's about the principle. Everything can't be about the principle. And I'm telling you stuff from experience, not from what I heard. I used to want to go and challenge everybody in court and do whatever. I'm going to do this just because. There ain't no way. They ain't getting away with that. I got to spend some money. No, sometimes, guys, it's better to have good bedside manners. You may give somebody cash for keys, pay your way out, move on to the next situation. Because most of the time, the only people that win in lawsuits are the attorneys, point blank. Next question. Who do I submit the land trust information data sheet to and for what reason? All right, I need for you guys to listen. All the documents that we created are private. They are your documents. You don't submit anything. Listen to me closely. So don't ask me another question about trust, about where you're submitting. There's only what that gets recorded. There's 2 documents that actually get recorded: the deed and the affidavit. Nobody's privy to any document, period. That's your personal document. Are you giving your will to anybody? The data sheet is for you so that you can have a recollection of the information that you use to make your trust and any reasons and notes as to why you created the trust. That's the only reason. Nobody gets your stuff. Remember again, your trust is a personal document. Personal. It's nobody's business. You created it for anonymity. So why are you going to give it to somebody? Can you put your property under a trust and pay rent from it to claim the depreciation by your LLC? Can you put your property under a trust and pay? See, guys, sometimes we go doing too much. If you put your property in trust and try to pay rent from it, that's fraud. We don't do anything fraudulent. We're not trying to do anything that's going to, there's too many things, guys. There's too much money to be made to be going out here doing some stuff that's just going to cause you to have problems. No, that your personal property is your personal property. We don't do workarounds. I don't do workaround stuff, okay, for stuff like that. That's fraud. And when you're dealing with banks, guys, you don't tell lies. You don't go start talking lies because that's bank fraud, mortgage fraud. You don't want to get reeled up in that. What if a seller's attorney wants to look over trust agreement before signing? Is that something to worry about? Typically, I've only had one time that I've had someone to actually want to take their documents to an attorney. And typically, guys, that's the same thing as if you have a contract. You go do a normal purchase and sale agreement, you're wholesaling something or whatever you're doing, and they say, yeah, I'll sign it, but I want to have my attorney look at it. Well, sure, you want to have your attorney look at it. I know, you want to have, I would highly recommend that you have your attorney look at it. Matter of fact, I think I'm gonna have my attorney look over stuff as well. I need to, because I want to make sure, I want you to be comfortable or whatever. I don't worry about that stuff. If a seller, typically, I'm going to explain this in a manner that the seller, and we're getting into subject 2 now more so than, which is tomorrow's topic, but I'm going to explain it in a manner where the seller is comfortable. The one thing that I will tell you about subject 2 is if you got to drag somebody, if or you're beating them upside the head to make them do this, or you're coercing them to do that, don't do the transaction, period. Point blank, because you're going to be married to this person for the tenure and time frame that you hold that property. And you don't, if somebody's not comfortable, First of all, I'm going to tell you, it's on you to get them educated in what you're doing to the extent that they trust you and they feel comfortable executing that transaction. It's all about you and how you sell it, okay? I don't try to lie about it. If somebody asks me, one of the questions that your seller is definitely going to ask you, well, the loan's going to stay in my name. Well, how long is it going to stay in my name? I can't tell you that. I have no idea. How many years you have on a loan left? Okay, you're in year 5 of a 30-year mortgage, so it's 25 years. Actually, it could run the whole term. I doubt it very seriously. It's our intent to try to make a profit somewhere down the road. But we don't guarantee you when it's going to sell. So, but we do guarantee that we're going to make the payments faithfully every month as to never impair your credit or jeopardize your credit. That's what we tell people. You don't make guarantees. And don't try, and let me say this on that. Don't try, and we, like I said, we're on subject 2. Never try to just tell a seller, well, it's only probably going to be a year or so. You never tell them that. Now, if you know you're going to go flip the property or whatever, then that's one thing. But don't go start trying just to get the deal. You say whatever you think you need to do to get the deal. Be honest, straight up front, lay it all out and tell them. And when you see the documentation I'm going to go over and give you tomorrow, you'll see. There is no doubt whatsoever what we did in this transaction, okay? Because we're going to tell them we're not trying to hide something. Sometimes, you're just trying to get a deal. We're so hungry to get a deal, we want to glaze over everything and not talk about something. I want the seller to understand. I want them to be comfortable. I want them to feel good about it. Because if you don't make them feel good about it, I can tell you what's going to happen. You're going to sign the contract with them at their house, and before you can get 10 blocks down the road or the next morning, they're going to call you up and say, you know what, me and my husband, we talked about this last night. I don't really think we want to do this. Okay. All right. And then you have to go back and look at you because you didn't sell it. You didn't close it. All right. Regarding the trust bank account, is it only the security deposits that go through the account or do all transactions? Don't get them confused. Don't have anything to do with trust. Don't have anything to do with security deposits. Remember what I said when I talked about that. A trust bank account for security deposits is a separate account maintained by you as a landlord to hold your tenants' security deposits. The security deposits are accounted for through your trust bank account. It never goes to that actual trust bank account. That's not what that's for. The actual trust bank account is a separate bank account that you're holding on behalf of your company where you're funding just enough. So basically what you have is, if you look at these boxes I have here. So just pretend like this is your trust bank account, and the second box, so this is your trust bank account, the bigger one, right? So you got all the funds going into your trust bank account, which is kind of like account that's hidden away because it has its own it has its own taxpayer identification number. Now, what you're going to do is all of your operating stuff is going to come out of your business operating account. So if you know that on a monthly basis, I need $20,000 to maintain my operational expenses in my business. So what you're going to do is you're going to fund from your trust bank account $20,000 to this account so that at any time, the maximum amount of money in your regular operating account is just enough to cover the expenses. So if something happens and somebody wants to come at you, the only thing you got in this account is just enough money to cover your expenses. All your real money is in your trust bank account that they don't see or know anything about. Everybody follow me? And going back to your question, if you have a business operating account and you have rental properties, then you're going to have a separate bank account that maintains your trust deposits or your security deposits. That's your trust account. All right. That's your trust account. And that money is not commingled with your operating expense account. See, many of us as landlords, we make, because we don't know what the heck we're doing, because many of us become landlords by default. You know, if you have a tenant that's your monthly rent is $800 and the security deposit is $800, you take all $1,600 and put them in your bank account and start spending money. I know some of y'all keep looking at me because some of you got properties and that's what you're doing. You're going to get yourself in trouble. That money, that security deposit money is not your money. It does not go in your operating account. It goes in a separate trust account that you have to account for. You have to account for that money, and you better be accounting for that money. Let me give you an example real quick. If you're in the state of North Carolina and you're renting properties, you have to disclose to your tenant where you're maintaining that security deposit money within 30 days of taking that money. Typically, we write it in the contract. Your $800 is being maintained at Wells Fargo Bank as interest bearing or non-interest bearing. And if it's interest bearing or non-interest bearing, it's not bearing interest to your benefit. It's bearing interest to my benefit. When you get it back, $800, provided you didn't tear up anything. Okay. Now, how do they find out you didn't do it? If a lawyer knows what they're doing, they throw everything at the landlord. They say they get in a lawsuit, they throw everything that they know most of us landlords who don't educate ourselves don't do. They know we don't like to maintain property, so they throw that at you. Failure to maintain the property in a habitable manner, failure to maintain security deposits in accordance with North Carolina or state statutes. How did they find out? Because it had to be deposited within 30 days, and you have to have a bank statement and a ledger that shows it. So a year from now or 7 months from now, you're trying to kick your tenant out, and that's what they allege, and they do disclosure. They say, well, you didn't maintain the security deposit the way you were supposed to do it. If that tenant gave you a security deposit on March 1st, sometime before March 30th, that money should be in your trust bank account. If it's not showing there, no deposit was made, you got a problem, and it could be deceptive trade practices. So that's why I tell you it's incumbent upon us to know what we're doing. Next question. Let me see. My LLC is already established, and I wholesale. My LLC is a single member. How do you make the LLC flow through an S corporation? Basically, you have a couple of different options. You can actually just convert or apply for an election to change your current LLC to be taxed as an S corporation, and then it will be a flow-through entity by virtue of being that S corporation election. It's still a flow-through entity now, but it's a single-member LLC, so it's a disregarded entity. It just flows through to you personally, and basically you're operating that LLC for the most part as a sole proprietor, because the IRS considers an LLC, single-member LLC, disregarded entity. So basically, you use Form 2553 and make an election. Usually, they can go back 75 days from your election and give you credit for that, right? Or you can just start off a whole new LLC taxed as an S corporation and do something else with the one you have. That's your options. Where do you find reasonable salaries? Yeah, that's a good one. You're going to typically, you can go through and try to do data and stats. There's no real place to actually just go and look that information up, what everybody's making. But I would not, basically, depending on what you're actually doing, I wouldn't get so wrapped up in it, because truth be told, most of us, there's some of us that are out here that's doing business, and you're doing business at another level. What do you think the average, you know what's going on, most of us know what's going on in our marketplace. We know who the movers and shakers are. Most people aren't doing anything. How many people are actually really doing something at a level where they're, quote unquote, talking about a bunch of real money? All right. But I'll see if I can find you. I'll make a note and see if there's something I might be able to recommend to you for getting that. Next one. All right. One time, what does my business structure look like if I wholesale, assign, I have rentals, and I want to save on taxes? All right. Then that depends on what you actually want to accomplish. As I said previously, you can have an LLC that's an actual holding company that does actually do flips and assigns. But you're going to have an operating agreement that basically says that those wholesale and assignment transactions are basically for you to generate cash flow and capital to buy rentals for your long-term hold. I would tell you to actually look at the number of transactions that you're actually doing in the wholesale and assignment arena and how much money you're actually making, and also versus how many actual rental properties you have. If you only have 2 rental properties or 3 rental properties and you're wholesaling 15 houses, then more than likely you're looking like a dealer on paper. So the highest and best use of your individual tax dollars or tax benefits is going to come from you having an LLC taxed as an S corporation, and then for your rentals, having an LLC taxed as a partnership. Okay, I'm going to do 2 more questions, guys. 2 more. How does the process work when a property management company is managing your property? I guess I don't know whether you're asking that question relevant to a trust or whatever, but it's the same as any other process. You're going to do a contract with the property management company based on the terms of your agreement with the property management company. Property management company is managing the property on your behalf, and you're paying them whatever 10% or whatever you're paying them as a management fee. They're collecting rents and doing the whole 9 yards, and then they're simply just sending you a payment. It's no different whether your property is in a trust or whether your property is or whether they're managing on behalf of you personally or your LLC, same thing. How far back can I amend taxes? I need to amend 2017. You can go back 3 years. Now, they're not going to let you go back 3 years and amend your taxes to be an S corporation. I'll tell you that right now. You're going to go back 75 days. They're not going to let you go back and think you're going to, hey, what's your reason? I went to the Tony Robinson workshop. You told me this is what I need to do. You're going to have to move forward from where we're at right now. That ain't going to happen. Was that one? All right, guys. That is the conclusion of day 1. Day 1. Tomorrow we're going to get into the subject to process. We're going to talk about how to actually do subject to. But before we get there, we're going to spend some time in the morning on personal property trust. We're going to talk about how to set up a personal property trust, which is pretty much the same. If you can do a land trust, you can do a personal property trust. Basically the same information for the most part. We're just talking about a different asset, same documents and forms for the most part, except one we're talking about a title or deed. The other one we're talking about personal property, which in most cases does not have a deed, although a car would have a title. All right, so we'll talk about how you do that. So we're going to talk about how to put your car, bank account, and other personal property in a trust. And then we're going to get into the subject to and talk about how to use what we've learned in regards to trust to be able to go out, execute subject to deals if that's what you desire to do. So we're going to talk about that in great detail, talk about how to get the seller to understand that they may need to pay you to buy a property. We're going to talk about how you can actually be a problem solver by knowing how to execute this transaction, execute it ethically and above board. And I'm going to say again, I'm going to preface this, and I'll be really, really hard on it tomorrow. That transaction is not for everybody. All right. It's an advanced investor strategy. I love it. It's a great strategy, but you have to evaluate where you are in this business. It's not for everybody. Okay. There's a lot of people out here selling it and talking about it like, it's the best thing since sliced cheese. And I agree, it is. It's one of the things that actually helped me acquire a lot of properties and build up my portfolio substantially. But again, I educated myself. I learned the process. I know where I am in this game right now. If you're just getting started, you just got a few properties, you're not well educated in real estate at all, it may not be what you need to do right now because there's a lot of exposure for you. So I'm just going to tell you that straight up front. But you may need some coaching through that process. And I'm just going to tell you, there's a lot of individuals. I see some of these people out here selling subject to trainings and programs and stuff and talking about what they don't know. You don't know what you don't know. So if you only been doing this business a few years and you went out and did 3 or 4 subject twos just because you did them and you got away with it or you haven't had any problems, don't mean that you know enough to be an authority on it. Only when you've been in this business long enough to have some longevity behind you to know this stuff. Matter of fact, I wish I'd have kept that phone call. I may have it. I just got cussed out. Today's Saturday. I just got cussed out Wednesday for a property that we just sold that the seller told me it's a D shame. You had my property. I don't understand. You had that loan 16 years. I said, I'm getting ready to send you another $2,500 to what I told you 16 years ago. That check will be in the mail. I'm mailing it to today. You should have it by Thursday or Friday. You good? You doing good? You good? Hope you're good. You're staying safe. Moved on to the next subject. All right. But that's what she told me. All right. This is after I had her property for 16 years. Matter of fact, I'm going to demonstrate tomorrow because I actually have an email she sent me probably 6 years ago or 7 years ago in about 200-point font that say, hey, Tony, you took this property and it's only been 100 years basically. And I want this thing out my name. I'm going to show you that actual email. So what I want to tell you guys is subject to is a great strategy, but it does have its perils, because people forget about how great thou art somewhere down the road. So you don't want to get married to those transactions, right? To the extent that, I know a lot of people would like to go out and buy these properties and do owner financing with them and all that. We'll talk about that tomorrow. But now you're in the middle of two people. So you got to watch what you're doing because, guys, I'm going to tell you, when you do a subject to, you're married to that seller for the length and time that you have that property. All right. And that seller, like I said, is going to forget how great thou art. Today, when you met that seller, they're 4 months behind and getting ready to face foreclosure. 2 years from now, they've remarried. Their credit is in better shape because you paid that subject to. And now they're trying to buy a new house and somebody tells them that their debt to income ratio is too high because of the house that they no longer own anymore. And you have to remember that because the longer that you go with that house, then basically they're totally detached from that house. They don't care about that house anymore, right? And now it's just an impediment to me moving forward in my life. So you have to understand that they're saying from their perspective, every time I go to buy a car, they're telling me about that house that I don't even own anymore. Every time I try to buy a new house, they're telling me about that house that I don't own anymore. So you have to decide where you want to be. Now, I'll say that to say that we have a substantial portfolio subject to properties. And I deal with everything on an individual case basis. And you learn how to use good bedside manners to deal with people. Okay, get called up, get cussed out, be polite. Thank you. Miss Brown, I know you're mad at me. I can feel it. But you know what? Miss Brown, when I met you, you were 5 payments behind. And if it actually truly, if it wasn't for me, you wouldn't even have a house. You would have had a foreclosure. And so now, guess what? In regards to that house, you have A1 credit because we paid every payment faithfully, just like what we told you when we met with you. Have we not done that? Yeah, you have. But it's still in my name. I said, yeah, I know, but we working on it. We working on it because we don't really make any money either until we sometime down the road when we actually can sell that house and realize a profit. Okay, get off the phone. All right, guys, that's it for today. I hope you got plenty of notes and a lot of information out of today's session. I look forward to seeing you in the morning. And so let's, what I would tell you, if you made notes, go back and look at your notes. I would usually tell people to make your notes in your, either in your booklet or somewhere on your pad. Go back and match them up with the pages in the booklet so that you can, and do this while all that stuff is fresh in your mind. You want to try to marinate on it a little bit. Most of the time, guys, we go to seminars or we go places, take notes. 3 weeks later, we put the stuff up and then we forgot everything. So try to, particularly most of us are on shutdown in most of our areas or limited movement or whatever we're doing, social distancing, you know, marinate, study, and try to grasp these concepts that you got. Understand, this is an advanced strategy, guys. This is not, you know, you may have to do stuff like this over and over. I did in my life, I have done at least 11 subject to classes by 11 different individuals. Okay. And I learned something from every one of them. You know, my wife sometimes tells me we'll go someplace and somebody's teaching and she'll say, I was waiting for you to get up there and start teaching. But I go there as a student because you can learn from anybody. Okay. You never know what someone has to offer. And so always be learning. Always be learning. That's my advice to you. Always be learning. I'm always learning. I'm even, 24 years in this business. I'm still learning from all these guys that are around me. You know, you guys, deal machine and land glide and doing all the technology stuff. You guys keep me. Hey, look here. Y'all know, guys. Y'all see, these guys keep me from being an 8-track. So, all right. So the Maxwells and those guys, they keep me from being an 8-track. All right. So I could be a VHS, right? But I try to stay fresh, all right? Because I can't tell you what happened, what worked for me in 1996 ain't working in 2020. All right, guys, good night. Have a good night. Rest up.